Hey, I'm Paul Rabelais, and in this video we're going to talk about mistakes to avoid when bequeathing real estate. I'm Paul Rabelais. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. If you watch some of my videos, you realize I don't talk too much about my personal life, but I'm still kind of giddy about, I've been talking about my LSU Tigers. I'm filming this video on Tuesday, January 14th. Going to be published for the first time on Wednesday morning, 10 a.m., January 15th. Monday evening, January 13th, Tigers won the championship. College football, beat Clemson. It was a big deal. And me and my four boys were at the game. It was a late night. So it started early in the French Quarter, walking around, complete chaos, complete insanity, just nuts. And then led to the game at 7:15 start, and game ended like at 11 or 11:30. By the time I got home, I live 80 miles away. It was 2 a.m. And then, up the next morning, here we go. So, but it kind of got me off my schedule. I like to get up really early, go exercise, do my video, and then have the rest of the day from, 9 a.m. on to get my law practice stuff done. Nonetheless, Tigers won. Hey, go Tigers. All right, so back to the grind, though. See mistakes happen a lot in bequests of real estate when it's, things aren't addressed just right. Sometimes people want to carve out a specific bequest of either maybe their home or some other kind of non-home property that they have. Sometimes they want to leave their home or property to one individual and then leave the rest of their estate to other individuals. So we have to specify things in the estate planning documents, whether that's your last will and testament or whether that's your revocable living trust. So let me go through some of the mistakes that people make, and you can make sure that you don't avoid them. This is all about empowering you to make the right decisions and not make mistakes. All right, so first let's talk about the home, and then in a minute we'll talk about other real estate. So when someone makes a bequest of their home, we get asked all the time, Paul, do we need to give you the full legal description of our home? Not just what the property tax notice says, but the full 2-paragraph legal description, which looks and reads like a bunch of legal mumbo jumbo. And normally in the estate planning documents, we don't list those full legal descriptions. We just list perhaps the physical address of the property, just enough to describe it sufficiently to be able to identify it. So, Dad may say, I leave my property at 123 Sesame Street to my wife, and I leave the rest of my estate to my kids. Maybe his wife is not the mother of his children, so he wants to do that. So first of all, we don't have to put all that legal description in the estate planning legal documents, just the physical address enough to sufficiently describe it. Now, not so general that you can't say I leave all of my property, or I leave my property in. I leave the piece of land that I have in East Baton Rouge Parish to Fred, and maybe when you die you have 3 pieces of land in East Baton Rouge Parish, and so that's too general. So anyway, sufficient enough to identify it. All right. The other area that's a real watch out for this is sometimes someone will create their estate planning legal program and they want to leave their house to somebody, spouse, child, whoever. And so they say, I leave my home at 123 Sesame Street to Jack. And let's say a wife did that because she wants her home to go to her husband, Jack. So she says, I leave my home at 123 Sesame Street to Jack. And then, years later, after she signs the will, she sells the home and buys another home at 789 Sesame Street. Well, she dies. Her will says, I leave my home at 123 Sesame Street to Jack. Does Jack get the home at 789 Sesame Street? Probably shouldn't. So in that wife's will, maybe she should have said something like, I leave 123 Sesame Street to Jack, but if I sell this home and I get a replacement or successor home, this bequest would apply to that successor or replacement home. Something to that effect. I wouldn't use those words exactly, but you get the idea that you need to cover. If you want to leave somebody your home, you need to cover what would happen if you sold your home and bought another home, and you'd want them to have that. So be aware of that. All right, so when you leave your home to someone, in my mind, there's 4 different ways to make a bequest of a home, and insofar as what rights that person will have. The first of the 4 I'm going to go over here, pretty easy to understand. It's where you leave ownership of your home to someone. I leave my home to Jackie, and so I leave my home, or I leave, 123 Sesame Street to Jackie. I leave ownership to Jackie, and pretty easy to understand. You die, guess who owns the home? Jackie. She can do whatever she wants to it. She has ownership, it's hers. So that's what's called outright ownership. There's a second form of ownership, common as well. I leave my home at 123 Sesame Street in trust with Jackie as perhaps the income beneficiary of that trust to last for Jackie's lifetime. And then when Jackie dies, those trust assets revert back to whoever I had designated as the principal beneficiaries. It's a way for you to make your home available to someone, but when that someone dies, the home reverts back to the people that you would want it to revert to, not the people that the person that you left the authorization to use it to be able to control where it goes. So that's in trust. That works everywhere. Then there's 2 other Louisiana forms of ownership that I'll go over that we see sometimes when people write wills and leave bequests of their home. Sometimes they'll say, I leave the usufruct of my home to my spouse. And so that means they have the right to live there. It means they have the right to rent the home and receive that rental income. If they rent it to someone else, that usufruct is that use and fruits word. And then another one we don't see too much is I leave my spouse the right of habitation, which means all they can do is live there. They can't rent it out and collect the rent. That right of habitation is a little more restrictive than that usufruct, but that's another form of ownership that we have in Louisiana. Now, if you use any of the last 3 that I just mentioned, we talked about ownership as ownership, they do whatever they want to with it. But if you leave your home either in trust, or if you leave the usufruct, or if you leave the right of habitation, you have to put a term on all of those things. When does that person's rights to live in the home, to occupy the home, when do their rights terminate? If it's a spouse, will they terminate when they remarry? Will that terminate when they die? Will it terminate, your spouse's rights terminate when they live with someone like they're married? So those are all provisions that we have to make when you give someone that right to kind of use or occupy or live in your home, but you want it to revert back to other people at a later date. All right, another key point when you're bequeathing a home is you need to address the contents of the home. So if you say, I leave my home to my wife Mildred and I leave the rest of my estate to my 3 kids, and you die, yes, Mildred's going to own the home, but your kids may come in and clean her out of all the contents because you didn't specifically bequeath her the contents. You just specifically bequeathed her the property. So that's just something that needs to be addressed when you do carve out a specific bequest of a home is, furniture, household items, all those things that perhaps needs to be addressed separately. All right. Here's another one. If you have a mortgage on your home, so let's say husband has a $800,000 house, but he has a $250,000 mortgage on the house, and he wants to leave his wife that house and leave the rest of his estate maybe to his kids or others. If he wants to leave her a mortgage-free house, he not only has to leave her the house, but he also has to provide that bequest is free of any outstanding mortgage, such that the mortgage is to be paid out of his residuary estate. So that means she gets the house, and then other money that he has would go to pay off that mortgage, and so she would own the house free and clear. So if there's a mortgage on the house, you need to address how you'd want that structured. Okay, so that's pretty much the basics for what to watch out for and some common mistakes that people make when they bequeath their home. Now, Many people have family property, they have land, they want to pass that down to the next generation or two. So just, having the conversations with so many people who have done that over the years. Let's say a wife has 150 acres. She got it from her father or her mother or her parents, and she wants to, the long-term goal is to, keep that property in the bloodlines, keep it in the family. So sometimes that wife says, well, I have, my 150 acres, and so I have 3 kids. I'm going to leave that to my kids 50 acres each. Well, it doesn't necessarily work out that way. So when a parent or when anyone leaves property, real estate, to multiple people, mom leaves 150 acres to her 3 children. When they inherit it, when it's just left to them, when they inherit it, they don't necessarily each inherit 50 acres. And I realize 50 is 1/3 of 150. But I want you to understand the distinction. What the children inherit is a 1/3 undivided interest in 150 acres. Now, so it's when the kids get it, it's not 3 tracts. It's not a 50-acre tract A, 50-acre tract B, and 50-acre tract C. It's not that when they get it. They get a 1/3 interest in the whole thing. Now, perhaps if that property is divisible, and sometimes 150 acres is not divisible because you've got something really, really valuable on 2 acres of the property, and then the rest is just not very valuable. So there are many, many tracts out there that people own that are not susceptible of being divided. And so maybe for the long haul, those kids are going to be 1/3 undivided co-owners. But if the children want to, and the property is divisible, then yes, the children can get the 150 acres surveyed, come up with 3 new tracts, 3 new legal descriptions, so that child A has their tract, child B has their tract, and child C has their 50-acre tract, or whatever the acreage is, to make it as equal as they can make it in value. So be aware of that when you're bequeathing real estate to multiple people. All right, so that should clear up and get you started so that you don't make some of the common mistakes that people make when they're bequeathing real estate. Make sure you stay tuned. I'm plugging away here and having fun. And even like when I did this video today, what's exciting to me is, because I don't want to say anything wrong, it causes me to just go double check my thoughts and my facts and make sure I'm right on top of it. So it's making me a better estate planning lawyer, and hopefully sharing some information with you out there so that you have some peace of mind that and you're kind of empowered to do what you need to do to protect what you have for your family. Make sure you tune in every 10 a.m. Central Time every day, where I'm gonna keep providing you with valuable information. Make sure you hit the subscribe button and the notification bell so you don't miss anything. And then, contributing comments down below are fantastic. And then if you can give it the thumbs up, if you think this provided you with some value, great. If you've already subscribed, thank you for that. I'm trying to just grow that subscriber number, make it worth my while to carve a few minutes out of my day every day to provide you with some education. All right, y'all have a great day. We'll see you next time.